Thank you, Paul, for that introduction, and thank you all for joining me here today to discuss contractual approaches to supply chain disputes. My name is Thomas Allen, and I'm a partner and global lead for international disputes at Kilpatrick Townsend. I think that if you are joining this presentation today, you're probably well familiar with the background of current supply chain environment and the challenges that exist in that environment. COVID-19 has caused stress to a global supply chain that was already showing strain due to protectionist trade policies at the end of the last decade. Virtually everyone that plays a role in the supply chain, from manufacturers to contractors in construction projects, anyone that has any link in that chain has been impacted by the current challenging environment. Those impacts can be seen in terms of labor shortages, diminished shipping capacity, increased shipping costs, regulatory delays and other delays at ports of entry, material and component shortages, as well as transportation bottlenecks. And while many of us were hoping and thinking and praying that we would be turning a corner at this point in time, as of this taping, we have the emergence of the Omicron variant and the reimposition of travel restrictions by certain countries, as well as threats of additional lockdowns. So all of this really points to an uncertain near term with respect to the global supply chain and whether or not we will see a recovery or return to pre-pandemic production levels. Now, what types of impacts have these stresses been having, and what types of claims will they potentially give rise to? Well, the answer is a variety of claims, and a variety of types of economic damage can arise from supply chain disruption. There are any manner of breaches of contractual obligations that might flow from the current supply chain environment. You may encounter receiving products on a delayed basis. If you're a supplier, you may be responsible for damages for delayed or failed deliveries. The lack of available equipment or raw materials could impact the construction industry, causing project delays, extension of time claims, change orders if you need design changes because of material substitutes or equipment substitutes. There may be indemnity claims because, in fact, the supply chain is, an integrated set of players throughout the chain. You may have a party breach an obligation to your organization, which causes you in turn to be in breach up the line in the supply chain. So indemnity claims, either against you or in attempting to recover from a party that has caused you to be in breach, are also potentially implicated, as well as performance guarantees. And those sometimes come in the form of third-party guarantees, parent guarantees, or other types of instruments that are intended to guarantee performance. And of course, these types of claims may implicate insurance in a variety of business interruption contexts. And it's important, I think, to keep in mind that while many of your existing contracts are going to have limitations and exclusions on the types of damages that can be recovered in supply chain disputes, absent those limitations and exclusions, it's important to note that some of these claims may give rise to consequential damages. So these can be significant in terms of their economic impact. I think it's important to distinguish between existing contracts and what types of behaviors parties are going to adopt moving forward in the future in terms of how they negotiate and address their challenges in their supply chains. I think this is important because for existing contracts and ones that don't have special provisions dealing with the types of issues that we're seeing today, there may be limited grounds to excuse non-performance. The grounds that we see most often asserted by a party that is not able to meet its supply obligations are those in the nature of force majeure, frustration of purpose, and commercial impracticability. And while these claims can be successful, if you've practiced in this area of law at all, or if you've ever even just done basic research on recorded decisions with these types of excuses for non-performance, you find very few instances where a claim of force majeure or frustration of purpose or commercial impracticability is sustained as an excuse for non-performance. So they are rare in terms of their success. That doesn't mean that they're never successful. And I think certainly in the context of some regulatory orders that might require facilities to shut down and those types of orders that have the force of law, those could implicate force majeure, for example. But I don't want to dwell on those claims too much because I'd rather make this about looking forward. But let's touch on force majeure in a bit more detail because it's probably one of the more popular excuses for non-performance. Force majeure is a contract-based claim that is fact-specific. And I just handled in 2019 a force majeure case for a large claim for a long-term fuel supply contract for a nuclear power plant operator. So I've got some specific and recent experience with this. Typically, force majeure is an event that is not the fault of the party claiming force majeure, and it's something that has happened that prevents a party from performing their contractual obligation. Events that constitute force majeure are often listed in your contract. They may include things like natural events such as earthquakes, floods, fire, plague, acts of God, and other natural disaster, or man-made events such as acts of terrorism, riots, war, embargo, strikes, or labor shortages, and changes in laws and regulations. At the beginning of the pandemic in early 2020, we saw a lot of activity in updating force majeure clauses to also include pandemic-related clauses. It's important to keep in mind, though, that as we are talking about a number of the different challenges within the supply chain, a lot of the challenges that are facing companies today are not preventing their performance, but they're making the performance under the contract more expensive and more economically burdensome. And typically, economic harm or increased economic burden is not going to be considered a force majeure event because it does not prevent a party from performing their contractual obligations. So purely economic reasons are usually going to be insufficient. And that's why we'll talk about exploring other mechanisms to give parties flexibility. Other aspects of force majeure is that the party asserting force majeure does need to make commercially reasonable efforts to try to remove the event of force majeure. So they must try to mitigate and take efforts. And I think it's also worth mentioning that foreseeability is a question in some jurisdictions with respect to force majeure. And what we mean by foreseeability is there's an expectation that the force majeure event is not something that the parties would have foreseen at the time they entered into their contract. Well, when we're talking about contracts on a going forward basis, we're now close to 2 full years of pandemic related disruptions. So it begs the question about whether a force majeure event related to the pandemic has in fact become foreseeable at this point in time. And the legal implications of whether foreseeability exists is something that you would want to explore in more detail if you're either defending against a force majeure claim or asserting a claim. But I want to really look more ahead and give some practical advice and some ideas about how we might implement new contractual clauses moving forward to help address some of the issues with these supply chains so that we can avoid being in dispute, so that we can avoid being in arbitration for these types of claims. And I mentioned arbitration and not litigation because, well, it's not really the subject of my remarks here today. Whenever we do have cross-border deals, the enforcement regime and the ability to enforce arbitration awards across borders in 160 countries under the New York Convention, in my view, makes arbitration the preferable mechanism for disposing of these types of claims. But in any event, what would we recommend from the outset? Well, examine your supply chain. Communicate with critical vendors and partners to try to get ahead of potential issues. That's easier said than done, I think, in this environment. But try to identify special situations that might give you some priority in the supply chain. Consider diversifying your suppliers so that you're not merely reliant on one or two companies. And in preparation for this talk here today, I spoke with a number of in-house lawyers to ask what types of strategies they have been doing to address supply chain challenges. And one of the major ones we hear is companies really shrinking their geographic footprint within the supply chain. And what I mean by that is they're literally trying to redeploy resources and assets and move manufacturing capabilities to areas that are nearer to the markets that they're serving. It's kind of an obvious and logical principle to say that the less distance that you would have to travel, then the less chance for interruption and the less obstacles you would encounter within your supply chain. Companies are also telling me that if they have critical inventory items, some of them, if they can, are trying to secure those items in advance and even holding more inventory than they might ordinarily hold because of the current climate. Now, if you either are having trouble meeting your contractual obligations or you've received a notice that your counterparty is not going to be able to perform their contractual obligations, what advice would we give you? Well, I think you need to understand and evaluate the individual facts and circumstances. Mostly everything that we're talking about here from a legal perspective is going to have an intense factual inquiry associated with it. That's certainly the case with force majeure type situations. You want to monitor the situation in real time. The current situation is fluid, and the new variants that we're dealing with at the time that we're taping this session show the fluidity of the current situation, meaning that facts and circumstances can change quickly, so you need to stay on top of these issues. You need to know what your contracts say and understand the implications of your decisions before you act. Since this is an ongoing issue for many companies that are making accommodations that are potentially waiving some of their contractual rights or doing things that might have an impact of other rights within their contract. Really, before you send any notices or take any action, you want to review your contract to understand the consequences of those acts. Keep detailed records so that you can document your costs, document the efforts that you made to perform, document your damages if you're the party that is owed performance, so that if you do end up in a dispute, you have a fulsome set of records within which to operate in that dispute. As I mentioned before, review your insurance coverages if those are potentially available. And then there is, because the impacts of the supply chain crisis are so broad and impacting so many companies, there is some incentive here to try to reach business solutions as opposed to dispute solutions. So consider whether there are alternative means to perform contractual obligations, and consider business solutions. I'll put a footnote right here on one of these. I was discussing with a company the operation of Incoterms with respect to shipping terms for contracts, and how they often specify a port of entry or a delivery port. Well, if you take the Port of Long Beach, for example, which has been in the news lately for having backups and regulatory delays and custom clearance delays, etc. If you had flexibility in your contract that required delivery at Long Beach, and you could instead move to some other point, move to San Diego and move your product by truck, have the ability to have that flexibility within your contracts. That's something that I think can be useful. So what are some specific provisions that can give you some flexibility? Well, price review clauses. Now, these are clauses that provide for review and possible revision of rates charged in the terms of a contract based on a specified event or set of events. What's common to these types of clauses is they usually include a trigger mechanism that allows one party to initiate the procedure. They have defined contractual procedures for how the price review will occur. There's usually a negotiation period, and if the negotiation period fails, then dispute resolution mechanisms, and typically arbitration, can be implemented to set the price. And then there is a procedure in these clauses for implementing the new prices. Now, these types of mechanisms do exist in some contracts today, and I want to give you just two examples. First of all, the LNG market, particularly in Asia, has price review clauses in some of their take or pay contracts. Another common area, I think, where you can see price adjustment is in where you have a party that is paying in a currency that has a lot of volatility. That can also, we also see examples of currency adjustments where there is fluctuation beyond a certain percentage. And then I posit an example here that you could do that type of thing. You could build in a reallocation of costs if you have some categories of costs that exceed an increase or exceed an expected percentage or a defined percentage. Right now, shipping costs are said to be 6 times what they were last year in terms of the cost of sending one shipping container. So, that's something where you could build that in. You could build in some floor or some point where if you go over to the other side of that point, the parties will have a mechanism to reallocate some of those costs. Other things you can do, I think flexibility is key. Maybe instead with the volatile market, maybe instead of a cost structure that lasts throughout the duration of the contract, you might want to shift to contracts that are setting costs order by order. Now, you might be giving up some certainty there, but you also might be gaining some flexibility if you have some major market disruptions. You can give the supplier the right to increase the price under certain circumstances, or allow the supplier to pass costs through directly to the customer under certain circumstances. And if you have defined commodities that follow any industry pricing indices, you can rely upon and use those indices as an objective measure of what your cost provision should be in the contract or what your prices should be in the contract. And those objective measures and indices really would take things out of the party's hand. And we already see this process being followed for some commodities, such as fuel for power plants, for example. Other clauses to consider implementing: a most favored customer clause would essentially guarantee you the best pricing that's offered to any other customer. A step-in rights clause would allow the customer to use the supplier's intellectual property to fill orders if the supplier is unable to do so. This is a major advantage and provides additional flexibility. Access agreements that might permit the customer to use the supplier's production facilities to produce necessary products or parts if the supplier is unable to do that. And we've already talked about indemnity and refund provisions. And then finally, if you can, build in some flexibility. Lots of contracts have different rates and provisions where the price diminishes the longer there is delay in delivery. You may decide to include provisions in your contract that extend the timeline for performance of delivery in order to keep a party out of breach if there's business reasons to do this, and if there's business reasons to work with this supplier, if they're a particularly good one. You might also consider a temporary suspension of the contract. Stop shipment or termination clauses can be included in certain circumstances where a party can request an end or a pause to shipping. They also may want to build in termination rights if escalating costs make performance uneconomic. That's something that the parties could, in fact, negotiate, those types of provisions. And then finally, resourcing rights. This would be a situation where if you have raw materials that are dependent upon you completing your project or manufacturing your products, that you could permit customers to find alternative suppliers in emergency situations and not have those situations constitute a breach. They would again be, a flexible pause that would allow the relationship to continue and not be broken, but then also allow the parties that are being impacted to seek alternative mechanisms for performance without having to declare anyone in breach. So with that, I think that I have reached the end of my time. It goes by quickly. This is a meaty topic to cover in 20 minutes, so if you have questions, I've got my contact information here, and I'm happy to continue the dialogue at a later time. So thank you for your attention, and then I will now turn it back to Paul, our moderator. Thanks again.